Number one, the urgent motion.
Lordship, this is a simple prayer for speedy disposal of an application under section 12 of the Guardians and Wards Act. Lordship,
When did you file it?
Lordship, initially it was filed in the month of February 2025, Lordship. But there's a backdrop to that. In December, there was winter vacation in the district court, actually.
Yes.
Subsequently, after opening of the district court, the Bar Association of Darjeeling went for a strike, and it was closed for almost 1 month, Lordship. After that, January entire was closed. In the month of February, we filed this application, Lordship. On 2 occasions, Lordship, the matter was taken up. Matter could not be taken up for hearing on the ground that the regular PO was not sitting, Lordship. In charge was there.
You are appealing?
I'm appealing.
Lordship, in the meantime, when I filed this matter, an order was there for mediation. We went for mediation and it failed, Lordship. So now the stage is that the matter has been fixed on 19/7/2025 before the Honorable District Judge, Lordship. Now my simple prayer is that if an order is passed to that effect that before 19/7 or on 19/7, without granting any further adjournment on any ground whatsoever, the matter may be disposed of, Lordship. Only prayer with respect to section 12, that is the interim custody of the minor.
What is this? PO is absent.
Absent. In charge PO is not taking up matters other than bail matters.
No. PO is away on duty in circuit court. What is circuit?
Circuit court is in Siliguri. In a month, district judge comes to Siliguri to attend certain matters. Because the Lordship 438 power is not given to the additional district judges. So for 438 matters, district judge do come to Siliguri.
What do you say?
But with regards to expeditious disposal of the matter, my lord, I do not have any objection, my lord.
No. the applicant in this revisional application has filed an application under section 12, read with section 25 of Guardianship and Wards Act 1890. আচ্ছা 12 and 25 করে দাও, ঠিক আছে, read with 12 and 25, read with section 6 of the Hindu Minority and Guardianship Act, 1956. The you filed it on
27th February.
ওটা করে দাও, কি বলো?
File an application on the application of 12 and 15 of the Hindu on the Guardians and Wards Act 1890, the registration 6 of the Hindu.
Before the learned district judge at Darjeeling on 27th February 2025. The mediation has failed. The opposite party has also filed her opposite party has also filed her written objection. The principal grievance of the applicant is that the matter has been adjourned on 21st April 2025. আচ্ছা ওইখানে opposite party has filed the on on 27th March 2020. তারপরে 21st April 2025. On the ground that the learned judge was a learned district judge was unavailable and the charged court, being the court of the learned additional district judge, second court Darjeeling, did not take up the matter. The matter was once again adjourned on 24th Is it the correct date? The next page, the order is 24th February 2025. Because the previous date is 1st April,
It is not a correct date, Lordship.
the matter was again adjourned and has been lastly adjourned on 8th May 2025 on the ground that the learned district judge was away for holding circuit court at Siliguri, and the charged court being the learned additional district judge, second court, Darjeeling, did not take up the matter. The the opposite party is represented. The applicant says that a direction be given for hearing out the said application as expeditiously as possible. The opposite party does not object to such prayer. In the aforesaid facts and circumstances, the learned district judge, Darjeeling, or the court dash in charge is directed to dispose of this application as expeditiously as possible, but not later than 4 months from the date.
Next date is fixed on 19/7, Lordship.
Very well. 4 months from the date of communication of this order. The petition, the applicant shall be entitled to apply before the court of the learned district judge, Darjeeling, or before the judge in charge for preponing the next date, which is fixed on 19th July 2025. Nothing further remains. The additional application is
Item number 2, under urgent motion.
My lord, I appear on behalf of the petitioner. As directed for the second service, we have served it. Affidavit of service. Advocates have been informed, but unfortunately, they did not turn up, and the petitioners were also informed.
yes.
If my lords would remember, this case is against the rejection of Order 7, Rule 11, which we have preferred before the additional district judge, third court at Jalpaiguri. If my lord, if I may go to the brief of the case, on 5th February 2024, we had made an application before the Chief Judicial Magistrate under Section 12 of the DV Act. Subsequently, that was transferred to Judicial Magistrate Second Court. Subsequently, on 5th April, we had received an order for restoration of matrimonial residence with police assistance, and police was asked to file a report as to compliance of that order. That has also been filed and annexed. Subsequently, on 20th April, they came up with an application for desertion.
Yes.
Yes, my lord. On 20th April, my lord, they had filed and for dissolution of marriage on grounds of cruelty and desertion, the husband. So, my lord, if I may look into the statute, what has the desertion to say? That there has to be a desertion for a period of more than 2 years. Subsequently, my lord, those were admitted and were transferred to additional district third court.
See,
Subsequent-
desertion,
Yes, my lord.
desertion, you may say that it does not fulfill.
Yes, my lord.
But the plaint cannot be rejected because the cruelty ground is there.
Yes, my lord. On that ground, my lord, my contention is that a plaint cannot be rejected in part, nor it can be accepted. Either it has to be rejected in full or it has to be accepted in full. Part rejection of plaint is not allowed. But what I understand by what Supreme Court says, my lord, I have the judgments. If my lord would like to look into the judgments.
You are showing Sukonna holding. The first judgment is Sukonna holding.
Yes,
The plaint cannot be, that is the parent judgment.
yes, my lord. Even in Edelco housing industries and all.
All
Ye-
subsequent following Sukonna.
Yes. My contention is only that, my lord, if my lord may look into the plaint, they have admitted that yes, they are aware of the judicial order, but but in the plaint, none of the averment shows that there is ground of cruelty.
Take down. This is an application by the wife
White man.
assailing the order dated order dated 5th April 2025, passed in passed in MAT suit number 229 of 2024. By the learned additional district and sessions judge from a third court at Jalpaiguri. উপরে দিয়ে the affidavit of service filed in court today is taken on record. Respondents remain, the opposite party remains unrepresented. Despite service. Where is the service?
My lord, service, yes. This is the second service, my lord, we are making.
On a perusal of the plaint filed by the opposite party in Maxsuit number 229 of and the application under the provisions of Order 7, Rule 11 of CPC. আগে করা আছে তো? আগে একবার বলেছি Order 7, ওইখানেই করে দাও।
Filed by the wife, the order of the court without notified or to any matrimonial suit number 1.
By rejecting the applicants rejecting the petitioner's application under Order 7, Rule 11, Code of Civil Procedure 1908, in short CPC. Hello.
Filed by the maximum and the application filed by the petitioner and
It appears that I find that কি বললাম I find that on a perusal it is found that the main ground assailed for rejection of the plaint is but it is found that the suit has been the suit for dissolution of marriage has been filed on two grounds. That is the desertion and cruelty. The main objection of the petitioner is that the ground of desertion is not made out in view of the not made out in the plaint in view of the provisions in view of the relevant provisions of law
May I interject?
which are required to be fulfilled to plead desertion.
My lord, may I interject a point? Even that is admitted in the plaint itself.
The learned judge considered the application of the petitioner application under Order 7 Rule 11 of CPC filed by the petitioner and has held that the suit cannot be the plaint cannot be rejected and the suit cannot be dismissed because the other ground, that is cruelty, is pleaded it is also the finding of the learned judge, a trial judge, trial judge, that whether the ground of cruelty can be proved or not is not a concern at the stage of hearing of an application under Order 7 Rule 11. So far as the ground for desertion, it will be open to the petitioner, being the defendant in the suit, to plead and lay necessary evidence to rebut the charge of desertion and cruelty as alleged against her. The matter therefore requires
My lord.
Please. হ্যাঁ কি বললাম? হ্যাঁ।
So why I think now for the years time, the regular petitioner, the defendant interest to plead and they necessary evidence to rebut the charge of possession and guilty and there is legal stand. Matter they are going to rise.
To be heard on taking evidence of both sides. Post. I do not find any infirmity in the order. It is well settled provision of law that a plaint cannot be partially rejected. Post. Since the ground of cruelty is already there, which requires to be gone into by taking evidence, the plaint has been gone into the application under Order 7/11 of CPC has been rightly dismissed by the learned trial court. Infirmity বলেছে?
I do not find an infirmity in the order. It is the law is settled that the provisions of law that a plaint cannot be partially rejected. Since the ground of cruelty is already there, which requires to be gone into by taking evidence. Application on order of the rules.
No, taking evidence though, even if the ground of desertion is not available to the opposite party plaintiff. Rightly rejected, তারপরে be rightly rejected.
Or the application on order of the that will this by the
Rightly rejected করে দেবে। In the aforesaid facts and circumstances, this revision application is dismissed. However, without any order as to cost.
Item number 3, under urgent motion.
But pursuant to your lordship's last direction, that we had made an attempt to serve. That one of the opposite party received millet by hand. Millet, the other two opposite parties as well as millet, the learned advocate, millet has refused to accept. So that yesterday we had sent it by post. Millet, this is the affidavit of service. Millet,
You had sent it on which date?
that order was passed day before yesterday. Yesterday, millet,
You said you attempted to serve the.
yes, millet, it has been stated in the report.
Who is this Nivas Ghosh?
He is millet, the opposite party number 2, the seller opposite party. The seller opposite party. Arises out of a preemption proceeding.
Yes.
And millet, we have also millet affirmed a supplementary affidavit millet annexing the photographs that they are taken possession of the land and millet raising constructions thereupon.
Yours the pleading, I will not accept.
No, the pleading is there in the supplementary affidavit.
Why is the question? Why is the main application here? Why
But
is the
since
pleading?
that was not there, the urgency, millet, the for stay the prayer is there. for so far as Millard, my prayer for stay is concerned, Millard stay of the appellate order.
He has to be founded on some ground.
Yes,
I,
well, that-
I
that-
pointed out last time
Yes,
that there is no, you are asking for stay. And on the ground of urgency, that if the order is not stayed, then the opposite parties shall take step or further step to
yes,
change the nature and character and possession of the
Yes.
suit property or
Uh,
deal with the same.
those pleadings, Millard, I have seeking to brought on record, Millard, by way of a supplementary.
There is a judgment of the division bench of our High Court, single bench of our High Court. Supplementary affidavit, you cannot improve the case.
Millard, it's probably not improvement, Millard, it's just filling the gap that after filing of this, Millard, they have started raising construction. That's precisely what is stated. And Millard, in any event, Millard, if I can demonstrate to your lordship that Millard, the order is prima facie bad. I am, Millard, in any event probably subject to correction. If Millard admits it, Millard, I will be entitled to a stay of the appellate order. I am not seeking a injunction per se. But even if the order is stayed, Millard, we can take assistance from the local police probably by filing a complaint that order has been stayed. Kindly restrain them from raising construction. If Millard even doesn't pass an injunction per se,
Yes, take down.
grateful.
Affidavit of service filed in court today is taken on record. It appears from the said affidavit.
My
That-
supplementary affidavit, if you will accept.
It appears, that the opposite party number,
Millard, two
opposite party number 2,
has received.
appears to have received the notice served through messenger. The other opposite parties, where have you stayed, refused?
Millard, in my service, Millard, it is stated. And Millard, even the learned advocate, Millard, refused. The concerned advocate who attempted to serve, her name is also mentioned in the affidavit of service.
The opposite member who appears to have received notice, not to messenger, and other opposite parties.
Other opposite parties would not be served since the petitioner says that they refuse to accept the learned advocate representing the opposite parties before the trial court and the first appellate court
First appeal, both same.
has also declined
Yes.
to receive the
Is that if they refuse to accept, it accept.
refuse to accept the notice.
Opposite party, the airport, and also the and the first appellate court.
Has also declined to
Receive the note.
declined to receive the notice attempted to be served on him by the petitioner. The matter therefore is taken up in the absence of the opposite parties. The subject matter of challenge in this revisional application is is the judgment and order dated 16th May 2025 passed by the learned additional district and sessions judge from Fast Track Court Roman capital 2, Alipurduar, in Miss Appeal number 13 of 2015, by which the order passed by the learned trial judge. Have you annexed the trial court's order?
Yes, both
Which,
certificate
which,
copies.
which? Oh.
You got the order dated 17th April 2015. Both certificate copies are there.
কি বললো? আচ্ছা, ওর উপরে করে দাও সাপ্লিমেন্টারি এফিডেভিট filed by the petitioner is taken on record. না, ট্রায়াল কোর্টের অর্ডারের ডেটটা দিতে হবে। Appeal the judgment and order.
By which, no, by which the order was by the market. Trial judge,
Dated 17th April
2015.
2015 was upheld. Appellate order, the first appellate court order, the position. After hearing the petitioner and considering the materials on record, I find that the matter relates to preemption. On a further scrutiny, it appears that there are certain issues which are required to be heard. This being the penultimate date of this circuit bench, and that the opposite parties remain unrepresented. In hearing of the revisional application cannot be made. The petitioner prays for stay of operation of the order passed by the judgment and order passed by the order passed by the learned order being the first appellate court, as also the order dated is trial court. On the ground that if the same are not stayed, then the opposite parties taking advantage of the situation and the order will deal with the property and or change the nature, character and possession thereof. The petitioner has also relied upon certain photographs annexed to the supplementary affidavit to demonstrate that the opposite parties are carrying on construction at the subject premises. In the aforesaid facts and circumstances, the in the aforesaid pass, I find that the petitioner has been able to make out an arguable case poster. The balance of convenience and inconvenience is in favor of the petition.
Grateful.
Moreover, the orders now, moreover, if the orders are not stayed, the same may lead to multiplicity of judicial proceedings. May lead to multiplicity of judicial proceedings. In the aforesaid facts and circumstances, in view of the above, the orders dated also are stayed,
Grateful, extremely grateful.
are stayed for a period of 8 weeks
Grateful.
from date. The petitioner shall make a further endeavor to serve a copy of the application along with the copies of the orders passed in these proceedings, including the instant order upon the opposite parties, and file an affidavit of service to that effect on the next date posted.
Grateful. Very good.
Let this matter appear before the circuit bench available
Can appear before the next circuit also. But there's a 1 week gap. We will serve and come back with the next circuit.
next circuit bench.
Next circuit.
Next available circuit bench subject to its convenience.
Grateful, extremely grateful.
Mr. Ghosh,
Narrow escape.
I have gone through the order.
Only on the point of whether notice under section 5 can be treated to be this Gramin Shalish can be treated to be equivalent to service of notice under section 5. Statutory provision will probably mandatory. Has to be treated as mandatory.
The principle is, if the কি বন্ধ হয়ে গেল কেন বলছে উঠে যেতে স্ক্রিন ফিন সব বন্ধ হয়ে গেছে এটা স্ক্রিনটাও সব that Naji Ahmed's principle followed even till 2022 by the Supreme Court. If the statute provides for a thing to be done in a particular way
manner, it has to be.
or not
Not
otherwise.
That is not only the short one. There-
Item number 4, under arbitration.
In 4 items.
That is
Yes, Lord. Proceedings, meaning of the word proceedings in NCLT.
I checked it up.
Yes.
See, section 11 is a proceedings.
Yes, but there is a gray area there. Because there is this Delhi High Court judgment of Power Grid Corporation, which basically defines, seeks to define the word proceedings appearing in section 14. So essentially what Delhi High Court has said, that any proceeding that may be for the benefit of the corporate debtor will not be within the word proceedings, and there shall not be a bar with regard to those. So that essentially this section 11 proceeding is neither for the benefit nor for the
See,
so there lies the gray area.
that is correct. That's the reason I told you to check
Yes.
it up. I also checked up everything. See, the two things, according to me, since the rights are adjudicated in section 11, initially there was basically no adjudication. The court only looks at the section 21 notice, whether there is a life claim and there is an arbitration agreement. Now later on, with the coming of the judgment SMST Chandmari, which later on has created a long history. End of the day, at the section 11 stage, the court has to look into the document and find out whether it's a content in a compulsory registrable document, whether proper stamp has been provided, or whether registration has taken place, all this. So I think
Then we will let the order remain.
this is an application under section 11 of the Arbitration and Conciliation Act 1996. The respondent in this application has faced a proceedings has faced has suffered an order under section 7 of the Insolvency and Bankruptcy Code 2016, in short IBC. As a consequence whereof, a moratorium under section 14 as a consequence whereof, under the provisions of section 14, no proceedings can be initiated or continued. An application under section 11 of the 1996 Act has to be reckoned as a proceeding, as the court in a very limited scope has to look into the documents and has to look into the arbitration clause, which may be content in a document which is required to be stamped and registered.
No, that part has been overruled by the 7 judges bench. For the purpose of section 11, this stamping would not be required. The 7 judges bench re-interplay between the final review, which was not adjudicated.
Global, you come to the thing, the court has to look into it.
Yes, but for the
To
purpose of
find out,
section
to
11.
find out.
Yes, that was there, but my lord, the stamping
The-
would not ultimately affect the section 11. Even if it is an unstamped document, that can ultimately be adjudicated by the arbitrator. At the stage of section 11, the court need not look into the.
That is a totally different aspect. If it is an unregistered document, which is request compulsory, it will not go in evidence.
Yes,
It has to be impounded.
yes.
কি বললেন?
Our petitioner agreed.
No, has to look into the existence of the arbitration agreement.
Lord, may I take your lordship's leave?
Whether the subject claim is a live one and there is a proper notice under section 21 of the said act. In view of the aforesaid, this application cannot be proceeded with. Even otherwise, no fruitful purpose will be served by appointing an arbitrator when the disputes before the arbitrator disputes, if any, cannot be proceeded before the arbitrator for the embargo under section 14 of IBC. This application, therefore, is adjourned sine die with liberty to mention. Sure.
Item number 5 under
My
arbitration.
lord, item number 5, my lord, I am for the petitioner, my lord, I beg to appear online, my lord.
Lordship, item number 5, Leonard DSG, leg on court
Yeah.
number 4. Leonard DSG, leg on court number 4, Lordship.
My lord, this is a short application seeking for appointment of arbitrator, my lord, based on the
Well,
general conditions of contract of Indian Railways, my lord. My lord, I had to suggest one name which I have suggested, but the railways have not yet suggested any name from their end, my lord. It is the only question that is they have to suggest a name so that the arbitration tribunal could be formed, my lord.
Mr. Mojumdar, on ground of Mr. Mojumdar, a passover has been sought for. Let me see. No one is interested in doing matters. That's the whole difficulty.
My lord, want to dismiss the matter, then they will be interested. In our principle, which is same thing.
Item number 6.
See, Mr. Rai, you know my views.
I know the views.
If I dismiss the matter, I am not doing justice to the litigant because he has engaged an advocate. The poor fellow does not know that his advocate will not represent him. So end of the day,
Again, restoration, again.
restoration. Yes.
Lordship, it's a arbitrator. Section 11. What happened, my lord? I'm the owner of a warehouse.
No,
There's a arbitration clause.
See, is there any dispute regarding the existence of the arbitration clause?
No,
Yes.
there is no dispute.
Is there any dispute as to the validity of the claim, that it is not a live claim, long barred claim?
This is
No, that is not
for the determination of the lease, man.
lease.
It's a question of determination of the
Determination
lease.
of lease. A lease.
Man,
Lease-
what I
lease-
entered a lease deed,
lease-
man,
lease
registered
deed.
lease deed.
lease.
So it is, your has been expired. There's an arbitration clause. And I given a notice to them for, dealing with the position. They have not given. So I gave it 30 days notice for appointment of arbitrator. He has not for it. Everybody has not refused it. I asked for the time. Time is given. So it was an appointment.
Suggested name?
Lordship, there is the company and now is came to a sitting and they are
That will decide by the arbitrator.
Lordship, kindly,
No.
please,
Let me hear what?
Lordship, the company's the director actually he is in one of the director of the shareholder. He is in Delhi. Today he is come to the Siliguri and they have a sitting and they have been talk about with the client of the Mr. Rai about the amicable settlement because of
My
the
instructions are not correct.
Let us appoint the arbitrator.
Yes, you
If
decide.
you settle it.
kindly give me 7 days time.
No, my lord.
Lordship,
They are
in-
going on my lord for last 1 hour.
Lordship, in this matter, I am for the respondent, Lordship. Mr. Amritam Mondal is appear virtually, Lordship. Respondent, এখানটা 1, 2.
No, your lordship, I appear in item number,
Next
no,
matter.
not in item number 6. 7, I am appearing in 7.
Lordship,
Can you, my lord? And the number.
no, that is high, it is high.
It is factual. 2 years. Problem? These are very. My lord, can you? Number,
No, আমি
number.
নিশ্চয় করবো কিন্তু আমাকে
No, no.
কোম্পানি
They practice, my lord.
that received this.
When was the section 21 notice served?
Long days back, December.
December, Lordship. Yes,
No, 10 September to ঠিক করে বলি, ভুলবার কথা বলবি না। 10 September 24.
15th.
They said I come by 15 days, they give me a letter also. 15 April to, I can see, 15, he said I'll come on 15 April, decide, and did not turn up. This one delay, but can you will decide.
No, Mr. Rai is correct on that point. On that point, because of as I inquire from my client, Lordship,
So neither here nor there. If you suggest a name, it's well and good, otherwise.
I have instruction for they have to sit.
It's the motion instruction, it is one, I will see before the arbitrator,
No.
they will decide.
No, Lordship, I'm giving.
Only drag the matter.
Giving my word, Lordship, kindly give me 7 days because of they have been got a meeting today.
No, my client said that there's no meeting.
This is the pair. No.
There's no meeting.
No.
Mr. Rai, no, see,
Lordship,
section 21 notice was given in December,
Lordship, September.
in September. So nearly a year, your clients could not sit when the matter is before the court, and on the penultimate day, your client will come from Delhi, will come from Timbuktu, and will sit. There is no question of adjourning it. Let me appoint the arbitrator. If you suggest a name, well and good. Otherwise, I will appoint.
Lordship, can you Lordship, give me a short password. I talk with. I'm 5 minutes.
নাম পড়ার জন্য
না আমি বলে আমাদের বলছিল তো এই করা
কি বলে?
সেকশন আমি বলতে চাই আমাকে তাহলে এখন একটা জানি জাস্ট
No.
জজ খাত
Then your junior will come and say you are engaged in number 2,
No,
number
no,
1, number
no.
6.
demonstrator is other side.
No.
Chamber junior is other side.
Sorry.
No. The divorce. Not
What's gonna happen?
Lordship, can you give me 2 minutes password? 2 minutes. Only the 2 minutes.
Next. আমি আছি।
Item number 7.
Here, my lord, there is,
7, I appear for the respondent, your lordship.
there is agreement, unregistered agreement for specific performance.
Notarized document.
Yes.
No, it's unregistered specific performance. They took the 87 more.
Huh?
They took the 87 lakhs.
No, it is all right. Yeah. Whether, see, specific performance of an unregistered document, of an unregistered agreement can be,
This new law, I got it.
what?
That you lost that regarding stamp. Is that you lost said.
Now the stamp issue, if it is.
Arbitrator.
i-
But then they filed I filed a shoot. Then they filed a section 8 application. That was allowed. I came with the Honorable High Court. That was a revision of the dismiss. Then I given notice of section 21. And only they said, the issue is not live. They have taken the money, they have not performed the performance. It was happening. Money from Calcutta, any minor, from any can it happen, anybody might not.
Yes, my lord. Only one thing, my lord, I cannot stand in the way, my lord, because there is a section 8 filed by me before the learned trial court, and it has been ordered. My lord, thereafter, they have preferred a civil revisional application, which was dismissed. So today, my lord, I cannot stand in the way of appointing of an arbitrator. Only I am seeking one thing, my lord, I will not blame anyone, but the husband of the petitioner, my lord, is an influential advocate in, my lord, North Bengal. So if anyone from Calcutta, your
Yes,
lordship.
yes, I'm also.
Yes, so that anyone from Calcutta.
If Mr. Rai will be appointed as arbiter, then yeah,
What is the tentative value of the claim?
My lord, 3 crores and odd, because 3 crores and odd.
The value of the land is more than 3 crores. We have paid the 87 lakhs already.
The value of the land would be 3 crores and odd.
It's correct one.
Yes.
You also carry.
My lord, may I propose a name subject to the convenience of my learned friend and acceptance by your lordship? My lord,
We should not say it. My lord will decide.
very well, very well. Yes, yes.
That's better. Both of us will not say.
Yes, absolutely, absolutely.
My lord, think and appoint.
Yes, I will give a former judge.
Yes,
Very well, as your lordship pleases.
because it's thinking.
Because the difficulty is that the recently retired judges,
Yes,
many
yes,
of them,
both are no problem.
no, many of them are holding some office or the other.
Yes.
Yes,
That-
yes.
That is the whole difficulty.
Yesterday on matter, Justice Madhuvanti Shah. Justice Madhuvanti Shah, I have one.
My lord, your lordship had decided to appoint a former judge subject to the convenience of my learned friend. If, my lord, I may propose Justice Shamapti Chatterjee, I think there would be no objection from the other side.
Justice, if I say,
You can't say no.
Very well, very well, very well. I will then appoint Justice Chatterjee's elder brother.
Very well, very well. Your lordship does. Yes, yes.
I work, yes, I work with many.
This is an application under Section 11 of the Arbitration and Conciliation Act 1996. The existence of the arbitration agreement is not in dispute as the respondent had made an application under Section 8 of this of the 1990 of the said act of the said act to refer to have the suit filed by the petitioner for the suit now for the disputes in the suit filed by the petitioner referred to arbitration. First, the revisional application challenging such order under in the application under Section 8 of the said Act has also been dismissed by this court. First, there exists live disputes between the parties, and appropriate notice has also been appropriate notice under Section 21 of the said Act has also been given. Post. In the aforesaid facts and circumstances, I appoint Ajoy Krishna Chatterjee, Senior Advocate, High Court, Calcutta, as the learned arbitrator to enter into reference and entered into reference and adjudicate the disputes and differences between the parties. The learned arbitrator shall be entitled to the fees in terms of the no, in terms of the in terms of the in terms of the said act read in the light of the judgment.
Fourth schedule, subject to your lordship's correction. Yes.
Fourth schedule. It's a judgment that.
Fourth schedule of the said act.
Yes.
Read in the light of the I will give you the judgment. I am unable to.
So
It
meaning
says-
judgment on the arbitration.
Huh?
Lordship,
Supreme Court, Supreme Court. Supreme Court.
no, Lordship, I will take one day. I will get.
Yeah, see,
2018 9 SCC.
more recent, 2024.
24.
Four, yes.
24, where the Supreme Court has asked the courts to the high courts to frame rules towards the fee.
That's what is Dr. Chandrachud's judgment. On 2024 4 SCC 481.
Probably that.
It's mine.
You'll find at the end of the judgment, the high courts have been directed to frame rules. Yes, 2024 4 SCC 481.
Yes, yes.
Paragraph 128.
2024 4 ACC 481.
481.
Yes.
Paragraph
128.
128.
My lord, that in that case, my lord, the fourth schedule will not be applicable.
Oh. It is for interpretation.
That is ready.
Very well.
Law is already.
The learned arbitrator shall be entitled to clerical and other assistance for which the parties shall equally bear the expenses apart from meeting the remuneration of the learned arbitrator and other incidental expenses.
Deeply obliged to it.
Arbitrator. I know. My lord, I can't say anything.
Mr. Ghosh is here. You ask him whether he will take up the assignment. Post. This is an application. Section 8, there is no dispute as to the existence of the arbitration agreement. Appropriate notice has been given. The claims are live. Vikramjit Ghosh, পুরো নামটা জেনে নাও। বিক্রমাদিত্য ঘোষ। ওই একই।
আপনাকে যদি আপনি বলুন
দেখেন
Matter, item number 5.
For the for the appellants, my lord, petitioner, my lord.
Yes, where is Mr. Mujumdar? পাস ওভার করো আর কি করো।
Item number 8 under civil motion. Number 8.
কি হলো কালকে ম্যাচ কোথায় চলে গেল দেখো পাস ওভার করো আর কি করে
Item number 9.
And for the petition, against that order of the debt recovery tribunal. There was a direction upon them to start. Deliver.
Please, what is it? Against what order are you?
Was palpably bad, which will restrain me from disposing of any other property apart from the one on which mortgage was created. So that we are agreed by only that line. Probably they will also agree that it should not have been there.
Yes, what do you say? Yes.
Meghnath. Meghnath. Obviously.
এই ইয়ে যাচ্ছে না কেন You please go out, give him a call, ask him to log in.
নয় চলে গেছে বলে 10
চলে গেল।
But my affidavit of service, it's showing delivered.
Which bank?
It's Indian bank.
Indian Bank. Yes. My lord.
এই তো।
My lord.
Yes. Sir, you have to make some infrastructural investment if you want to do the matter virtually. আচ্ছা, বুঝো। ask him, ওই পরেরটা ডাকুন।
Item number 10. Yes.
Item number 10, I have not responded.
You are for the respondent.
Respondent are 1 to 5.
Who is for the petitioner? Possible কি করবে এটা আমরা
Item number 11. Item number 11.
My lord, in item number 11, I am appearing on behalf of the petitioner, appellant petitioner. I am being led by Mr. Shamul Kumar Dash. My lord, would be very grateful if my lord kindly permit me to submit the fact in a very nutshell. My lord, in this application, the petition and the other side is being represented by Mr. Ratan Bonik, who is representing on behalf of the Punjab National Bank.
My lord,
yeah.
I'm representing the Punjab National Bank. But
no, in the
but
other
no
matter,
copy.
in the other matter, item number 9, are you appearing?
No. Initially they informed me, but ultimately some other lawyer was interested. I am representing this case, that is item number 11 on behalf of the Punjab National Bank. But no copy, my lord, my humble submission is that no copy has been served.
The copy is here, but unfortunately, Mr. Counsel is.
এই ওই দিনকে ইন্ডিয়ান ব্যাংকের হয়ে কে অ্যাপিয়ার করছিল বলো তো ওই মামলাটাতে ওই সিও
Someone had appeared, my lord. My lord, someone had appeared from Kolkata, my lord.
No. Someone had appeared from Kolkata, but the local advocate was also there.
My lord, I'll just check, my lord, in that Speed Fast Constructions case, my lord.
Yes.
In this matter, my lord.
Yes.
In this matter, my lord, only instruction has been given to me for appearance and to take a copy. Kindly make a direction to serve a
copy is
upon
ready.
me.
The copy is ready, my lord.
Yes, you can hand over it to my junior.
Where is your junior?
Yes, sir. Biswaraj is there. Biswaraj is there.
Probably he will be available in Benaras.
No, my lord.
My lord.
Yes.
My lord, Mr. Deboshri Dhar had appeared for Indian Bank, my lord, local counsel.
Item number 11 চলছে তো এটা।
Yes. Item 11 ইয়ে করো so appears on behalf of the opposite party bank and prays for a copy of the application to be served on him.
Copy service.
So-and-so appears and submit that he has the instruction to represent the opposite party bank and seeks for a copy of the application. A copy of the application is made over in course of hearing. Let this matter remain in the list.
Grateful, my lord.
No further. Yes, Mr. Ghosh. You talk to because in one of the very hotly contested matter, Mr. Deboshri Dhar was appearing and he was being led by some advocate virtually.
Short matter, though the last day, short matter maybe, I'll speak with it, whether it will appear.
এই কাগজটা তোর খাতা
Under court order.
Actually, for password, it's being filed. It's being filed. The memorandum of agreement is being filed. Settlement. It's being filed. Password, short password. Come at two. Yes.
Item number 2, under admission of criminal appeal.
Your Lordship, I'm for the appellant's lordship. I'm praying for next circuit. In the cost factor, it is showing there's a defect, and when I ascertain it, it's showing 115 days of delay. Section 5 needs to be filed, which we have not carried out till now.
Appellate. So. Granted liberty to your as
Point to
by by the additional as pointed as pointed.
Indicated in the report, the office report.
Item number 3, under matters in application.
I am led by Arun Kumar Chakraborty, Arun Kumar Chakraborty, advocate on records. Service not completed.
What matters, which one is the party?
Restoration application.
My lord, I seek indulgence to appear online for NCT in this matter.
Yes.
For NCT in this matter, I
Your
seek
Lord.
indulgence to appear online.
Yes, you are audible, but you are not visible.
Lordship, I stand correct. Lordship, there was a difficulty in the camera, Lordship. So, Lordship, I pray for indulgence to appear online, Lordship.
Yes.
For NCT,
What do you say?
Lordship.
नहीं वैसा बोला है बड़ा टाइम चाहिए restoration and section 5 section 5 yes in respect of this application what do you say
Lordship.
you are one of the respondents.
Lordship.
Is an application for readmission of the app and restoration of permitted application is for
27/9/2024.
27 September. The application being cancelled of has been filed. On 17. Along with an application for formulation of the can
Your 23. The service for the applications according to the appellant of the petition. According the service of the applications according to the application is not complete. For the respondent of the petition is represented to virtual pool and other respondents remain unrepresented. Yet, appellate petitioner solve the open of this application along with the notice informing the respondent that this informing the respondent that the applications shall appear for the next sub publicly.
Obliged, Lordship.
Number 4, under application civil.
My lord, on the last occasion, lordship has heard this matter, my lord, matter was admitted. And only for the purpose of stay application, my lord, lordship has granted liberty to the respondent to file opposition. My lord, this is my reply. This is my reply. My lord, advance copies have been exchanged. Now, my lord, the only thing I would say that, my lord, my learned.
Are you in a position to be hearing? Okay, take it up because today the penultimate, tomorrow we are not going to pay the matters for on the last. If you are ready, then proceed with the matter. In midway, don't ask for an answer.
My lord, I will say only one thing. Second. I will say only one thing. Lord, my learned friend has delved deep into the evidences. Now, my lord, at this stage of stay application, my lord, I have not dealt with anything in his opposition except paragraph 23 of the opposition. My lord, my contention before your lordship is in the month of November, my lord, he is, my lord, going to get married. And my lord, if he gets married, my lord, my appeal will become infructuous because he has a decree in his favor. So, my lord, unless the stay is, he is being restrained from getting remarried, my lord, I have no difficulty. Even if he says before this honorable court and he undertakes that he is not going to remarry, my lord, I will not press for stay. I am only on that, my lord. I have to see another one.
अच्छा specifically
It's not a divorce application, my lord. It's an application under section 12 of the Hindu Marriage Act. And doctor evidence, medical prescription, everything is there.
However, the order annulling the marriage, for annulment of marriage is under challenge.
Lordship.
Now, if you remarry,
No,
then
no,
what will be the use of the academic?
Yes, Lordship, I
hearing of the
absolutely that I don't have any idea for getting a second marriage because I know that the appeal is pending.
So you give that undertaking that you will not remarry during pendency of the appeal.
Please consider, this is an application under section 12, annulment of marriage, and the court has been practiced by the response by the
very well. The remarriage only upon leave in office of the. Yeah, arises out of the matrimonial needs to be then 170 of 2015 under section 12 of the Hindu Marriage Act, seeking decree of annulment of marriage. Yeah, it has been handled. So maybe in the application, wife being dependent to the as no,
They are still arranged out of matrimonial to bring such and such, that's transferable of the Hindu Marriage Act, seeking the decree of annulment of marriage.
Solomon is maybe.
Seeking decree of annulment of marriage.
The trial court has passed it, which is asset by wife. Being independent in states. That means that appellate and the state order you are asking for a state order or stay of the judge.
Restraint order will also do, my lord.
An order restraining the no.
Lord, in the application, I have request stay of operation of.
Okay, and any pass any other further order is there.
This application, the applicant is seeking.
Applicant is stay of the judgment and under application. On the ground that the respondent that husband is getting married in the month of November. The respondent opposes the application by filing principal ground of litigation. Stay is objected that it's under section 12 of the Marriage Act. And not be for solution of marriage under section 30 of the Marriage Act. After hearing the partner and considering the materials on the report, find that the applicant has been admitted and direction for preparation of
Paper books.
Because it will be only after the trial court report. Arrives
And as such, he did something. Unless the trial court records the revenue and he prefers it. People who are here. He cannot be hard. In the meantime, by in the meantime, on the strength of judgment that between to the husband, the remarried, then he and he will become incorporated, not sure. And it's likely to need to multiplicity of the children. The opposite factors are come from this. Entitled to imagine. Only responded correctly. Entitled to responded immediately. Entitled to imagine. Responded stating. Responded has been entitled to imagine. Only after specific reading from this. If so this will be during the pregnancy of the nothing further remains to be identified in this application.
Any time bound, they are calling for completion of the paper,
already there.
But there is no time.
See, the difficulty is elsewhere. There is no messenger, special messenger available in the circuit. Now, in the principal bench, if you take the special messenger cost, then the records will come instant. You can pass that direction. But here we are helpless.
Then, Lordship, please give me one opportunity for mentioning if the paper book is not being made within a reasonable period.
No one is preventing you. For mentioning, is there any bar?
But this shows the urgency of remarriage. This shows the urgency of remarriage.
I have to complete that.
The application will get.
Have you deposited special messenger cost?
Special messenger.
There is no special messenger here.
Huh?
There is no special messenger available in circuit bench.
That's seasonal.
But if requisition is being made on the department, record count.
You will pursue.
Filed by the respondent and the next slide we have to filed by the appellate. Taken off.
Grateful.
Grateful.
Item number 5, under unanimous appellate hearing.
Lordship, in item number 5, learned senior is down with fever. Your Lordship, I'm praying for next circuit.
Your learned senior.
Mr. Bodhan Bhattacharya, Your Lordship.
Matter was taken upon date.
Why not even requesting to hear the matter? Getting to the hearing of the matter. Today he is not there.
Yes, he was appearing before the Delhi High Court yesterday, Your Lordship. Keep the matter in the next circuit, Your Lordship. I'm praying for next circuit, Your Lordship. Up to you, man.
An adjournment to sort for. On the ground of the appellant. Appellant or appellate?
Appellant. One single person, single person.
Appellant. On the ground there. The council engaged on behalf of the appellant. To not in a position to conduct the case either by having it or to virtual or.
He's unwell.
Health agency. Are you sure? Because he submitted people correctly, remember? He is having, he will be having a case in the Delhi High Court
Yes, Your Lordship.
yesterday.
Yes. He got fever, Your Lordship.
The matter is at the this before the next certificate supplementary. The adjournment is already been taken up in the also good to the contact.
Item number 6, under mandamus of interim.
Filing an exception to the report. This is the appeal of the revenue department, sir. I am director, sir. Hearing responding to the order was passed in favor of the revenue.
Madam, I'm filing the report, madam. The report, madam. Report in the form of affidavit.
Yes, sir.
Yes, madam.
Report, the report to the report. On behalf of the respondent, bracket is revenue.
No, the appellant. I am appellant, revenue.
Sorry, appellant, bracket is revenue. And the exception here filed by respondent assessee.
Registered taxable article. Registered taxable person article.
Respondent assessee. No, I just respondent. Oblique petition. On the joint fair of the parties, this matter, place he was next. There is no point in the of the last day. Basically, tomorrow.
Look, I took only 3 days to file the exception because I wanted it to be done.
We have got it ready for the next circuit. That is now you do too.
I'm prepared.
I'm great.
Item number 7. Item number 7, mandamus have been heard.
Lordship, I'm praying for next circuit.
One to 10.
7, 8, 9, 10, 11.
The rest of the items for that I'm for.
Yes,
I'm for.
somebody was appearing online, leading you for, no other side. No, on that day.
No, Lordship. Lordship, Mr. Mominur Rahman sir was there.
Yes,
Mr. Mominur Rahman sir was there.
he was led by, an advocate who was appearing to us. Next circuit. Done over.
Item number 8.
Only 7 to 10. Mr.
7.
Mr.
Item number 11.
Appealing for the appellant, Lordship, this is appeal by the state, Lordship. Lordship, in this matter, there are some documents, if your Lordship kindly sees, there with the paper book, very illegible documents, Lordship, so I am praying for filing supplementary paper book in this matter, annexing the legible documents, Lordship. Kindly give 4 weeks time so that
Where is the paper book? Where was it?
paper book I have already filed. Lordship.
It appears that some of the documents contained in paper are illegible. The appellant is granted E5 an informal paper including legible copies of the document which are already included in the paper but are illegible. It's such informal paper could be filed by
Weeks. 4 weeks. Preparing paper book.
informal paper book, you will get it typed and
This such informal paper would be filed by 2 weeks
from by 4th July 2022. Let this matter appear because the next available certificate subject to
before the next
before the certificate available immediately after 4th July. Subject to
Item number 12. Item number 12. Item number 13. 14. Item number 15 under. Item number 15 under manual happy. Item number 15.
My lord, item number 15, I am lead by senior advocate Mr. Amalesh Rai. He puts his on his leg before court number 3.
Item number 16.
16 is that matter that I'm awaiting the copy of the decree, my lord. My lord, they my lord.
Item number 17 under arbitration.
Yes, sir. I am waiting on behalf of the National High Court. For the respondent.
But both of these matters, that 17 and 18. 18. But 17 and 18, Milord, although the parties are different, Milord, both relates to the same issue. So that both can be taken up together. Milord, the issue is, Milord,
Lordship, may I
First, Lordship, in item number 17, there is a section 5 application for condonation of delay. There is 181 days delay, Lordship. I am opposing the delay. I need to file opposition in this case, Lordship, because 181 days delay. There are several Supreme Court judgment, Lordship. In 37 April, 120 days is the limitation. After that, delay cannot be condoned, Lordship. 120 days, Lordship. 90 plus 30, 120 days.
Probably for 34, not 37.
No, Lordship. There is a specific judgment of Supreme Court. Lordship.
Popular constructs hard judgment. Yes, that has been diluted subsequently.
That is under, that is not, respect of 37, but respect of, section 34.
Yes.
No, Lordship. There is a judgment of 2018, Brindera Construction, Lordship.
Who?
Brindera Construction, Lordship. 2018 7 SCC 794, Lordship. Lordship, I don't carry the copy, Lordship, because I need to file affidavit in this case, Lordship. Lordship, give me 7 days time so that I can file my opposition, Lordship.
Which item?
17, Lordship.
17 कौन सा है हम लोग का सही दबा ये कौन सा वो 25 ये पर है ये 18 है
appears from the report of additional stamp report that there is a of 180. Have you taken out the application for
one can one
Can one is the application
इसमें लिखे थे हम
for condonation of hands. Is preferring the application.
3 of 22
Preferring which is under the provisions of section 37 of the arbitration and conciliation of the Act. Section 37.
37
96. On behalf of the respondent, we submit that submitted activity immediately on 120 days cannot be condoned. Immediately on 120 days.
citation
Yeah, is referring to LPC. Cannot be condoned in view of the ratio laid down.
In Brindera Construction,
Brindera.
yes. VARIN SEC 2018 7, page number 794.
2018 7 SCC
794.
790.
Sir, Lordship, two more judgments, Lordship. Two more judgments. To 2021 6 SCC. Government of Maharashtra. Bracket Water Resources Department represented through executive and engineer versus
Citation 2020.
2021 6 SCC.
Yes, page. Madam, when you are making the citation, the quoted judgment is the
We acted in the SCC 2087 SCC 794.
Observing the nature of objection,
Evidence in opposition we filed by 4 July.
7 days they asked for.
Five, 27. June 2025.
Reply within 7 days.
By 4th July 2025. Let this matter appear before the certificate immediately available after 4th July.
One request, Millard. Against the same impugned order, Millard, they have also preferred an appeal, which is Millard, FMAT arbitral award number 3 of 2024. Millard, let this appear along with that so that it can be taken up together. 2 appeals against the same order.
We are informed that this form has conferred an sensible judgment and order being the subject matter of the service. The same appeal is now he said not happy as the as
FMAT ARB award 3 of 2024.
In that paper books are complete.
No, Millard, that is also Millard pending for Millard for first consideration, initial consideration. The stay is under consideration, has to be considered.
Also appear along with this.
Grateful, Millard. उठेगा तब बोलते हैं ना 17 ही लिया है 18 में नहीं लिया 18 तो फ्रेश बोल
I will appear in
next circuit.
18 Millard after your lordship rises after the lunch Millard 18 I will place 18 there is no delay.
Lordship, in another 3 matters, I have to still paying for next circuit 12, 13 and 14.
Why?
That's DHA agreed also. Not well, 12, 13 and 14, similar.
With your other side.
Lordship, my step.
Unfortunate petitioner respondent.
Very good. Borrow there are party. Unique one, right? Yesterday actually we're hearing about regarding electricity. Is it regarding
already filed the terms of settlement at the department. That has been numbered as scan 2 application, but I believe unfortunately it has not arrived at the record.
Have you got the copy?
I have a office copy, Xerox, photocopy, a single copy. Later direction.
Point is within 20 days, they will make the balance payment and execute the jobs. We'll execute the jobs.
You are not interested in the settle. You have settled it out, it's your choice.
Yes, sir. Let me fix on the next circuit for compliance. It's after the lawful.
Order 23, we have to look into that is.
We're filing, sir. Later direction be to call the record, call the can.
Yes. You wait.
Item number 80 under arbitration.
This is also Millard, section 37 appeal.
Arising out of?
Arising out of Millard an order under section 34 passed by the learned district judge. Now Millard, before your lordship goes into it, Millard, it's a case of land acquisition under the National Highways Act. Millard, when the land was acquired, admittedly this was Millard a T grant leasehold land. Section 6(3) of the Estate Acquisition Act. Now Millard, when this land was acquired, the competent authority Millard paid a lump sum amount without disclosing any computation. Now, being aggrieved by that Millard, we went to the statutory arbitrator. The statutory arbitrator granted enhancement of the value of that amount and the valuation of the land, which we contended that according to some judgments of the Honorable Supreme Court, being the lessee, we are at least entitled to 70% of the land value, 75% of the land value. The learned arbitrator, without recording any reasons, in an ad hoc manner, arbitrary manner, held 40% of the land value. We were aggrieved by that. We preferred an appeal before the section 34 for setting aside of that award and hearing of this same afresh on the principles on which we were relying upon. Now, simultaneously, the Asian Highway Authority, who exercised who acquired the land under the 1956 Act, they also preferred an appeal. Their contention was we are entitled only to 10%. So, both these applications were taken up together by the section 34 court and disposed of by a common order. Now, the order has set aside, has allowed both the section 34 applications, it has set aside the word. Now, the reasoning is absolutely against me. The reasoning says that 10% is the appropriate amount, although certain observations are in our favor, that section 26 of the 2013 Act has not been taken into consideration, etc. But substantially, the observations yes,
There's sent back.
Not been sent back. It ends with the expression set aside. That's all. It ought to have been sent back, but we are
Statutory arbitrator
or the competent authority had to decide afresh, whatever. But the observations which are there, my entire case has been decided against me.
Lordship,
The
may I
points which
ask
we
one
had,
thing?
which
No, the last
which we have taken the points, which we have taken before the our representation before the competent authority, the points which we have taken before the competent authority and the section 34 court, Millard, entirely it has been yes, negated.
Yes, Lordship, can we see the impugned order, page number 21? Last ordering portion, let the copy of the judgment be sent to the office of the Commissioner, Jalpaiguri Division, and the arbitrator under section 335 of the National Highways Act 1956 for information and necessary action.
Necessary action.
What action the Commissioner will take?
It does not mean anything.
Yes, Lordship. Commissioner will take a fresh hearing, Lordship.
But that is her
Understood.
interpretation, but according to me, that does not mean anything.
Say, that's what I asked you.
Yes.
If the award has been set aside, it cannot remain in limbo.
No, nothing.
It has to go, somewhere.
Somewhere, yes.
See, in case of, say, let us take in case of first appeal. Here are, the civil procedural
Well,
code.
41 rule 33, what can be done through a judgment by the appellate court?
That apart, if you want to remand it back.
Yes.
You can, frame issue.
Yes.
Or you can set aside and, direct, afresh, all these things are.
But that direction has to be explicit. It cannot be subject to interpretation by either of the parties. That is my only contention. And Millard, we are grossly aggrieved, Millard, by the observations, and this has to, Millard, has to be substantially hard on merits. Millard, because Indra Prasad in Supreme Court in the Indra.
This court clarifies this, that the matter has been sent back for the statutory arbitrator or consideration of the matter afresh. Will you be satisfied?
No.
No,
No, Millard, we won't be satisfied.
Operation successful, patient dead. এটা হচ্ছে প্রাথমিক চিন্তা কত লং
Now, Millard,
চ্যালেঞ্জ করলো আগাম মজা সব চলে গেল
everything went off. Now, Millard, after the Honorable Supreme Court's, Millard, the larger bench judgment, Millard, there is no scope of modification also.
No.
It has to be go entirety. There is no portion that can be severed. Yes.
Majority judgment. See, this was troubling me right from right from day one. Sort of because I had on that side, I think a sizable amount. Two things. One is setting aside of award. Then what if the award fee has to be set aside? It has to be set aside as a whole all.
As a whole.
Then there may be awards which is only to be interfered partially.
Now that is permissible.
And
But if that can be severed.
there are series of contrary views for
Yes.
which Justice Doctors bench had referred and correct answer. And the other part which is required to be also clarified. Now, the jurisdiction of the court in case of arbitration is fixed by the end. Now, today, suppose you enter into an arbitration agreement with her. You are in Siliguri, you say in Delhi. Now, both the courts that Siliguri and Delhi will have the normal jurisdiction going by the cause of action unless it relates to an immovable property.
Yes.
Because the wording is same as this suit.
Same.
Now, the venue is chosen at matters. By that, you are conferring a jurisdiction on a court which otherwise does not have to be.
Yes.
It is contrary to the long-standing view of the Supreme Court in judgments by ABC Lamina following that. By consent, you cannot confer, but here, you are by consent, you are conferring jurisdiction to a court which otherwise does not have it. So in a Supreme Court judgment, but that part has not been clarified.
Some confusion has also arose in view of Justice Nariman's judgment in, I don't recollect the name, 2018-19 Millard, which on this issue. Lotus like this.
Same.
Something.
Something. This judgment is also by Justice Nariman.
Yes.
Now, this long say, of actually, international arbitration.
Exactly.
Because
Other unilateral rules.
procedure for getting
orders regarding the procedural aspect, you can approach the court or governed by the seat of the arbiter.
Seat of the
But that concept has no domestic arbitration. Without clarifying. That's created lot of trouble. See, that they will say, because somebody was knowing that Surface Act 31 I agricultural land partition. You could have delivered, I did not any that day, but maybe that told you. You could have delivered judgment. That even in view of the embargo, if one creates a security in respect of the agricultural land, it has to be treated, and that it is not agricultural.
So, Millard, I was only praying, Millard, for stay of the, Millard, the order of the, because, Millard, there are consequences. Why I tell you, Lordship,
See,
Millard?
I tell you, the moment you file the setting aside that prior to the amendment, it got automatically.
Yes.
After the amendment, if you have suffered a one award, then security.
Well, deposit.
Now here, you got some money.
That also taken.
From the statutory arbitrator. Now that has been, so there is no question of any security or anything. It will automatically.
No, Millard, my only two concerns, Millard. Number one, my execution proceeding is pending because for that admitted amount 40%, which was earlier about it, for that there is an execution.
We don't want the disruption of the expansion of the road because your plant will.
No, these roads are already constructed. There is no question of Millard. Now the specifically fact amendment, Millard, infrastructure projects and all.
Plant will show our order as crocodile cup wherever required and get things stored.
No, Millard, it's already a constructed 4-lane, Millard. It's near the Bagdogra airport. That is already constructed.
The
There is
implication of
no.
this order is very huge because the several tea gardens lands are taken by the authority for the construction of the 4-laning and 6-laning construction lot. So implication.
Millard, that is the reason, Millard, these observations required to be state that I am entitled to only 10%. Millard, one more thing, Millard. Number one, Millard, the execution proceedings are pending. Second, Millard, on the strength of this necessary action as it is written, Millard, a fresh process may be initiated by the commissioner, which will be again, Millard, to my detriment.
You have to go and say something that they are doing.
Millard,
Mr. Road, showing revision is pending before the High Court without any order of the I will see the district court of the trial court taking up the matter.
Millard,
Yes,
now,
sir.
Millard, days have changed, Millard. Now, Millard, accept.
They have prepared an application and we are going to file appeal. That last occasion,
Millard, Millard, there was a direction. Millard, there was a direction to deposit and the executing court directed them to deposit the amount in court. They are showing that appeal is pending.
No, Lordship. We have not prepared any appeal, Lordship. They have prepared appeal, Lordship.
Very well.
Millard would kindly consider, Millard, stay for a, Millard fixes a, Millard, timeline, Millard fixes a time limit, let this be heard out on merits, Millard, before the next circuit.
Appeal is under section 37 of the Arbitration and Conciliation Act 1996. You have to refer to it, same time. Which arises
May 30th, 2025.
That's even on the
which arises out of the judgment and order within 30 minutes passed by learned additional district judge from a third court from a third degree. In his judicial argumentation which is compartment of by which the equality and by which the award passed by the statutory arbitrator on what is the date of the award?
17th May 2022.
17th May 2020 has been set. The appellant says that against the same award, the appellant and the respondent had filed separate applications under section 34 of the same act. Both the setting aside applications have been allowed by setting aside the award. Prohibited of the award. The appellate refers to the merit of the order. Apparently, it refers to the ordering to demonstrate that the same is not sustainable. The appellant also includes an order of the order on the ground that conditions may arise if the order in view is not speaking. Therefore, the is objected to by the respondent.
Lordship, respondent number 1, because respondent number 2 is not appearing.
Respondent number 1. Respondent number 1. In case of the respondent number 1, that scope of taking aside application is very limited. The learned trial court has considered the award in the light of the ground available for setting aside award, and as such, no stay should be granted. In view of the discussion and by the party, the matter is working out. Yeah. Matter is working out. We have the matter, the application is working out. We have considered the partitions of the party and
the materials of the form and its qualification of the that no skill is necessary at this stage. Let me know. Happy. Now, here, we are in the penultimate stage of present section. Possibility of time. Let's start taking out the matter for today. Which is matter list. Would be next available subject. Madam, do you want to remove the efficacy? In respect of
No,
the
no,
application?
no, doctor.
The main application, if we can find it from the
I'll compose it. They have also filed an appeal, no.
No.
Actually, the last line, and the last line, this is number 25 for us.
So, 29 of next before
Case number 25 of 2024.
Our 29 of and option and 29.
Autumn is judicial at arbitration.
Also, you going to which is your appeal, which is your setting aside application.
25 teachers also
And
The 29.
and
29 is my appeal.
both application for setting aside of the award.
ওটা both আছে।
ওটা discuss করেছে তো ওর আগে the appeal preferred by. Now, the application for setting aside of the award preferred by applicant was numbered as this case 25 and and we want 5 to 5. National Highways.
No.
Okay.
Asian Highway law.
It's
Asian
not here,
Highway.
not here, not here.
Asian Highway 2. Asian Highway 2.
But 29 of Portugal. Actually, this year,
29 of 2022.
yes, I'm not that. ওইটা যে এটা করে কোনটা বা both the ওর আগে ওই সেন্টেন্স তো
So far as the execution proceeding is concerned, there's already been an order to deposit on the one.
See of the case nothing.
we will not go through that. Upstairs to do.
When the matter was waiting before the district judge, they have challenged the award. We saw the that the case is waiting for the district judge. In spite of that, but lordship, there is a sale on that education proceeding. We have filed a CO against the education proceeding that has been sailed.
এই পেপার বুকটা কি করে দাও
But that is one kind of sale.
Statutory authority to the informally law. Let the trial court record the box. Department is directly to a sufficient number of people. Property.
On 11.
Or really. But the property is direct or to that. Because of as exhibition careful. Only the purpose being made ready and physical.
partners shall be at given distinction with matter for very high or any extent. Other people see for any for having these happening.
Millard has observed, Millard, so far as prayer for stay is concerned, Millard, if Millard kindly observe, Millard, prayer for ad interim stay. Because Millard is not finally disposing of my stay application. So Millard, kindly don't, Millard. Millard has not heard it also substantially. Millard, let me see, Millard, if subsequently, Millard, if you can press this more substantially on merits, Millard. 10% was enhanced to 40%, Millard, by virtue of this. Now everything has gone. So that's why, Millard, I was pressing for a stay. Your Lordship is not minded, Millard. At least the ad interim prayer be rejected. If I can press the can 1, Millard, subsequently.
They can raise all the points before the arbitrator, Lordship, because the arbitrator will heard the matter afresh.
At this stage, বলা আছে। Oh, you are not even to stay at this stage. বলা আছে।
Millard, can you observe ad interim stay? Millard knows, Millard. Kindly, Millard.
Matter will be heard.
And only nine letters, but very heavy letters. And Millard, only ad interim stay has been excused.
You don't want to take any baggage.
And ad interim prayer for stay.
I am opposing Lordship.
Great, extremely good, Millard.
Stay application টা pending. Stay application টা pending করে দিন।
Can 1 is pending. Can 1.
No,
At this stage,
no,
order of
stay. Because next to be first at this stage. Next to be first at this stage. তাহলে stay application টা disclose stop করবে না।
Extremely grateful.
question. Item number 1. Please ask about the party instant have settled disputes intercept being the subject matter of the proceedings wherefrom order under appeals. The parts have filed the joint application. Can sentence taking out the term of settlement as to be said as we now on a perusal of the
Criminal case, whether any criminal cases, case are
No,
pending?
no,
Huh?
no, only civil case.
So you are saying that all are lawful? I read whether, I found that there is one question. You try to find out. Last year, criminal case. Criminal case is non-compoundable, can be withdrawn.
No, no, it's,
Huh?
no, since there is no criminal case pending between the
You
parties.
you
Only
are
civil
saying-
case or specific
You
purpose
are
of the
saying
contract.
no question of examination, no lawful, my lord. Now, so criminal, omit the criminal case, except the word criminal cases.
Your lordship, I have mentioned withdrawn all or any.
No, criminal case, the word criminal
There
case,
is a-
then you have to
There is no-
clarify that there is
There is one item.
compoundable criminal case. Otherwise.
There is no criminal case. Odhikantu door no the side.
Yes.
That is the reason why, lordship, I have written or any, if any.
Within 20 working days.
on a query from court, it has been clarified by the party that no criminal case. No criminal case.
It's pending in between them.
It's pending.
Only one civil case specific purpose contract we have fight against them.
In between what?
I believe there was one instance where a complaint was lodged. But I don't think so there's a specific case against DCO.
Oh.
I don't know.
Happy. We have been the second of the list of. Let's go to our. And also. The guidance should come for 98 or 2024. Bracket is CIS 39 of 1. Stands disposed of.
After due compliance.
Stands disposed of in terms of sector.
Right.
A degree be drawn up. Drawn up by making the terms of settlement indicated in the schedule whose application being cancer and service. Only part of the by teaching we say as part of
The matter is being disposed of, Lord.
Yes, on the terms and settlement, you have. Degree,
but we do not know, you have any idea, there is the drawing up of the degree department over here?
হ্যাঁ নিশ্চয়ই এরাই করে দেন ঠিক আপনারাই করবেন নাকি
No.
আপনারাই লাস্ট জিজ্ঞেস করবেন ওখান থেকে নিয়ে চলে যান ওখানে করবে অর্ডারটা করে পাঠিয়ে দেবেন না ডিপার্টমেন্ট ড্রপ করে দিই ফেসিলিটিটা আছে কি না আমাদের যে এখানকার ডিগ্রি জমা করার ডিপার্টমেন্ট আছে হ্যাঁ এনআরআই করে জমা করে তো ঠিক আছে এনআরআই করে আমাদের কাছে দেখায় আমরা ঠিক আছে the evidence or the connected applications by the stats. Connected, yeah. Quality and these are people. Also stands this photo without taking further order. Was there any interim order?
No.
Item number 19 under hearing civil.
Where is your other side?
On the last week matter appeared and service has already been completed except one, and subsequently I have set another set of paper book and all these are very Excellent. Lordship, very solitary issue, Lordship. Notice under section 13(6) has been issued, but in spite of that, suit will be under the TP Act. Only on this ground, suit has been dismissed, Lordship. Eviction suit, admitted position that notice has been served, rent is under section 3A. So there is no scope for any hit accompli is the eviction of the tenant. I am suffering for the last 5 years. My age is more than 80 years, Lordship.
We don't have the other side.
Very solitary issue, Lordship.
What is your other side?
Service has already been completed. I have
Service one has returned back.
and I have again served. It has been delivered to the addressee. This is the epidemic service, Lordship. One solitary issue that the notice
The solitary issue or the other issue.
very small
Yeah.
issue, Lordship.
Now the penalty will pay and to see the, if you have to hear the appeal, it will take time. And we have to give
I suppose it will not take time more than 10 minutes, Lordship.
we have to give an opportunity. The other side.
Appeal is of 2019, Lordship. I am waiting for the last 5 years.
No, appeal is 2019, what can be done? How many times did you appear when the matter was placed before the?
Not a
previous
single day I did not have had.
I thought the police order is what I adjustment to the.
This is the first time
এখন appeal hearing.
it appeared in the last month, Tuesday, Lordship.
Come to, you have to order sheet. I read it out for you to open. Despite detection of paper book, copies of the same are not served on the respondents. Accommodation is sought for on such basis. The conduct of the appellant is not serving the paper books on the respondents is unacceptable. Let the matter stand at them and be listed before the whichever subject to payment of cost assessed at rupees 5,000.
I paid, but without any fault.
Have
of
you
the
paid?
applicant, Lord.
Have you
Yes,
paid?
yes,
See,
yes.
I personally discourage this Ashottama auto inquiry. Should have, you are pressing for an appeal, here
we do not hesitate. Yesterday also we had an appeal and disposed it of the way. Not one appeal, two appeal. But we are in the penultimate day at 3 o'clock. You are saying that you will open the appeal when the other side is not present.
Then may I file the between opposition?
Yes, sir. Get through.
Item number 20 under hearing.
Yes, led by Mr. Bhattacharya.
But I'm on virtual mode, my lord.
Yes.
So I'm grateful, my lord. Well,
The hearing of the appeal cannot be done.
not hearing, my lord. There is the appeal. Appeal has been filed. It is a preliminary degree, and only for stay. What I am my peer view. Your lordship knows. Commission, everything will be done. Commissioner will be completed. I shall record will be brought. I shall prepare the paper book. And in the meantime, final degree will not be done. My lord has experience, madam. Your lordship knows that is the usual order of the High Court. My lord knows.
My lord, on the last occasion.
My lord knows, but I have seen.
See, you are challenging the.
They use an opposition.
You are
Preliminary
challenging-
degree. Partition suit. Only that my peer. My lord knows that order. Our High Court's order, only that usual order.
Yes,
Only usual order.
my lord, the appeal arises of a decree regarding the partition suit. The decree has been given in favor of the plaintiff, who is the present respondent in this present case. My lord, in this billing.
Partitions, shares and division.
Exactly,
Now,
my lord.
subsequent to that, the final because it is the first chapter of the suit.
Yes, it's the second chapter, the final.
Appointment of commission.
My lord, my lord.
Then examination of the commissioner, cross-examination.
My lord,
Leading to the final degree.
my lord.
Then submission of
By meets and bonds, my lord. As stamp duty and the my lord,
collector.
my lord,
Assessment, submission of that, and then drawing of the.
my lord. My lord, in this case, they have filed a stay petition. Against that, we have filed an affidavit in opposition. The main contention that the respondent have got the decree. Thereafter, they have filed the final degree petition. And in the final degree petition, the appellant and respondent both are contesting.
Stay.
The court will proceed, but.
My lord.
It's.
But shall not pass, final degree.
Final degree shall not be passed without
leave of.
specific leave of this court.
Yes.
Yes.
You prepare the informal paper book, because the moment the trial court records are directed to be brought before us,
My lord.
this for the purpose of final degree will get stopped.
My lord.
Only my type that peer, nothing else.
So we have filed affidavit in reply.
E3, 2, 4, 5, and then it is.
Well, this is the defender 1, 3, 5, 6, 7, and 8 is the appellant.
Proceedings or further proceedings of the party.
Yes. But there's a similar order,
ওরা ইয়ে করুক না, ওরা নিজেরা পেপার বুক করুক।
yes.
এই যে
I already handed over a copy of this honorable court, my lord.
Can too.
Can two.
Judgment and degree টা stay করছে।
Judgment and degree, my lord.
Preliminary degree টা।
Yes, preliminary degree.
Oh,
There's
My
a
lord.
preliminary degree.
My lord, one of the respondents is, service has not been completed. It's a respondent number 7.
whether you are requesting him?
No, my lord, he's not.
Bhattacharya,
Yes, my lord.
service upon one respondent number has not completed.
But all response have completed, but that return back. Return that is, but I cannot find the evidence of that. Other day also that submission was made. Then
My
he
lord,
paid for
the
approval.
respondent number 7 is contesting in the final degree proceeding in the trial court below. So it's very.
But when I
difficult to
filed,
assess
but
when my
just a minute,
learned
allow
senior
me.
counsel say the service
Allow
is.
me. When I filed the appeal during COVID period, but that was the provision. First to send copy of the appeal upon all the respondents. Thereafter file the appeal. I did it. Thereafter this applications everything.
But
And twice I have served.
They are contesting. They are contesting.
They are contesting. I'm saying. Just a minute.
No, they are saying you are intentionally you have not served upon them.
No. Everything with me. Everything with me.
But he is.
I have no
They are
intention.
contesting in the final degree proceeding. Respondent number 7.
I know his
And
personal
they-
matter. That is why his father is here.
No, this is not the personal,
Just a
but
minute.
we are contesting the.
Anyway, just a minute.
Some foul intention is there.
No. I have no foul. This is preliminary. What is my foul intent? What will be my foul intent? What shall I do?
The applications being one was disposed of.
My lord.
While the application was that. Now substitution application has been disposed of.
Yes, disposed of.
Yes. Disposed of.
But that too, we have to say that has been abated, my lord. I will take at the time of the final appeal here.
Substitution allowed.
That has been abated because that has been passed not within the period that has to be filed.
But
that will be
but
say at
that
the time of the appeal hearing, but not at this stage of.
Substitution has been allowed. But 7, I
Okay,
sent.
allow us to pass order.
Yes. But that is a problem, virtual hearing.
This application is the regular for stay of the which has been appealed against or which has been accepted in this appeal. The order of people.
By July, I handed over a copy.
No order of paper, my lord.
No, there is no
Order of paper.
Passes the final then the appeal will become impacted. Moreover, there is likelihood of multiplicity of things. If we appropriate factual circumstances, we find that the appellate is entitled to some protection so that the appeal does not come in public. In the opposite factual circumstances, the trial court may proceed. The trial court is permitted to proceed with the final but no final thing shall be passed unless any of the parties specifically obtain of this to enable the final pass. Can circumstance is therefore peaceful. So if it is the opposition of the
Everybody reply, Lordship.
Prepared by appellate after having the text of incorporated in the informal paper settled to the respondents. The settlement of index shall be paid within a period of 3 weeks from date. Informal people prepare within 3 weeks from date of settlement of index. Matter the appeal shall be placed before the next available service after declaration of informal people. The parties shall be entitled to mention
the ethic for the should in the list for the wants the former people are regulating by appellate and serve on this text and of their act.
But a lower court record be brought.
No.
No,
Lower court record.
no, no, no.
Informal paper.
Oh, yes, yes, yes. I get it.
Grateful, my lord.
I get sugar. Now I am leaving.
Item number 21.
Let's say we'll take by the website.
Why?
Item number 22.
I am for the respondent. I am praying for next circuit, my lord.
You are for the respond. Who is for the appellate?
I'm for the appeal.
What is the appellate?
The money refusal, dismissal of money suit. The evidence of the constituted attorney was totally disregarded. Contrary to 2015 Supreme Court, judgment was cited but absolutely misinterpreted. So as the Millard, I don't want to trouble your lordship enough. Trouble Millard.
So, see, we hear out. And the hearing is not concluded. Then, the waste.
Millard, just 2 minutes, Millard, if your lordship spares me precious judicial time although. Millard, on the occasion, Millard, when your lordships were considering the suggestions, Millard, there was one suggestion which we discussed amongst us.
I immediately, this time, body, was I had attended as the second, mostly.
Courtroom number two,
Writ matters, and I could not get many of the hearing matters done.
The suggestion was, Millard, that since now, in a month, Millard, we are having 2 circuits, 2 weeks, 1 week gap, and then the 4th week, another circuit is starting. So effectively 3 weeks, Millard, 4 honorable judges are in Jalpaiguri out of the principal bench. Now, Millard, instead of 2 weeks, if the circuits can be made 3 weeks at a stretch.
That we told, immediately, that if the farmer,
Yes, but it's a process. Obviously, Millard, when for the
suggestions, because the honorable, because the roster and how.
Definitely, but only your lordships can convey that this was also a proposal from the bar, because that will increase the number of hearing matters, Millard, our output will also increase. Because every 2 weeks, Millard, when the court breaks, Millard, there is a lethargy on our part also. 1 week gap, then again when the circuit starts, 2-3 days goes, Millard, in warming up. Recalling the old matters, bringing out the briefs, Millard, this Millard, decreases the output.
So you want us to, that when the circuit is not functioning, you don't go to the court?
No, Millard, mostly I don't, but speaking for myself, Millard, I don't generally go. And that is, Millard,
Next section.
Item number 23. This is a case against the dismissal of a suit filed by the husband for dissolution of marriage.
But that happened for the wife lordship. Yesterday only I have got the paper with lordship. For the sheet for that.
Next section.
Item number 24.
Lordship, I am for the respondents. The Lordship, the matter is being amicably settled in between the parties, so I'm praying for next circuit, Lordship.
Lordship, the talks of settlement is going on in both sides.
Submitted by the part.
And Lordship, kindly the matter may go out of the list upon the settlement.
We will mention, upon mention.
Upon mention.
That we are negotiating to arrive at an amicable settlement and amicable settlement. It's not start out of settlement. And directly to go about this you should got mention that the settlement is arrived at or there the there no settlement.
Yes, okay, Lordship.
Item number 25.
I'm for the happy night. You're for happy night.
Oh, what is the settlement?
Lordship, my client has applied for a post after the death of his father. In first compassionate appointment for a particular post. Lordship, my appointment, my interview, all the procedural things has been already done. Result was published. Then it was in the matter was not forwarded. Then my client filed a writ petition. Writ petition was heard, and upon the direction was given on the municipality to consider the same. This is the first part. Second, when hearing was done, all of a sudden they filed a memo. The memo which is not been filed anywhere. Neither they filed a copy of the same, neither I found it on the internet. On the basis of that, second writ has been filed that it's not the matter which they are talking about, and we are the legitimate person. Please consider us in fresh. But unfortunately, if our Lordship allow me to take the second order, writ petition second, at page 89.
Where is the August, right?
August. Lordship. Paper books have already been filed and delivered to them. If my small direction may kindly be given to. I have already served, Lordship. It has already been done. Every
Happy.
happy, Lordship.
There was advocates presenting to the court, not there are advocates present before the High Court.
Lordship.
Catch hold of any one of them and
Lordship, I have already intimated, but they are not very interested to do the matter. But a small direction may be help as your Lordship.
Item number 26.
Lordship, one indulgence, Lordship. I am Miss Sushma Shianovic was appeared just before. On item number 23, Lordship, instead of item number 26. It will be on item number 26, Lordship. We are appearing for respondent. Why?
Item 26.
We have wrongly appeared, Lordship. We have appeared for item number 23, Lordship, but it will be item number 26, this matter.
Item number 27. Item number 27. Item number 28.
I'm the appealant 20, my lord. Last talkish also, he was kindly allow me just give it, so what got lawyer to notice, the paperwork has already circulated. No, paperwork has already circulated to them, even they are not appearing. If you just kind of give it direction, madam. Other than nothing, yeah.
Item number 29 under hearing land
Well,
tribunal.
item number 29, Lord, Mr. Baki Shaukan is appearing for the petition, Lord. Lord, I am praying for the matter to be listed in the next circular, Lord. Much obliged.
Criminal appeal hearing. Item number 30, 31, 32, 33, 34, 35, 36, 37 with 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50 with 51, 52, 53, 54, 55 with 56, 57 with 58, 59, 60, 61, 62, 63, 64 with 65, 66, 67, 68, 69, 70, 71, 72, 73, 74, 75 under for hearing, 76 with 77 under for hearing death reference, 78 with 79 with 80.
Your submit circuit to